Welcome to National Liberty Alliance's weekly call. Today is Monday, January 26th, 2026. We broadcast live every Monday from 9 p.m. to 11 p.m. Eastern Time. If anyone is listening over, if you're listening over Rumble or YouTube and you would like to ask a question or make a comment, you can go to nationallibertyalliance.org and click on a weekly call for instructions to join us live by phone, app, or browser. If anybody would like to email a question, you can send your questions to questions, that's plural, questions at nationallibertyalliance.org. Please support our business partners. You can find their banners on the right side of the website, of which the proceeds go to support NLA's effort to save our republic. Also, please support NLA by donating $5 a month or more. Click on the donation tab, top right side of our website. Okay, we're going to pick up with our scripture reading where we left off last week. Let's see if I can get that together here. I didn't put this information up. No, wrong one. Be just a minute. Didn't open up the file. Okay. Wrong one. Okay, we're in 1 Corinthians chapter 11, read by Alexander Scorby. So 1 Corinthians chapter 11.
Chapter 11. Be ye followers of me. Now I pray you, brethren, that ye remember me in all things and keep the ordinance I delivered unto you. But I would have you know, the head of every man is Christ, and the head of the woman is the man. The head of Christ is God. Every man praying or prophesying, having his head covered, dishonoureth his head. But every woman that prayeth or prophesieth with her head uncovered dishonoureth her head. For that is even all one as if she were shaven. For if the woman be not covered, let her also be shorn. But if it be a shame for a woman to be shorn or shaven, let her be covered. For a man indeed ought not to cover his head, forasmuch as he is the image and glory of God. But the woman is the glory of the man. For the man is not of the woman, but the woman of the man. Neither was the man created for the woman, but the woman for the man. For this cause ought the woman to have power on her head, because of the angels. Nevertheless, neither is the man without the woman, neither the woman without the man in the Lord. For as the woman is of the man, even so is the man also by the woman. But all things of God. Judge in yourselves. Is it comely that a woman pray unto God uncovered? Doth not even nature itself teach you that if a man have long hair, it is a shame unto him? But if a woman have long hair, it is a glory to her, for her hair is given her for a covering. But if any man seem to be contentious, we have no such custom, neither the churches of God. Now in this that I declare unto you, I praise you not, that ye come together not for the better, but for the worse. For first of all, when ye come together in the church, I hear that there be divisions among you, and I partly believe it. For there must be also heresies among you, that they which are approved may be made manifest among you. When ye come together, therefore, into one place, this is not to eat the Lord's supper. For in eating every one taketh before other his own supper, and one is hungry, and another is drunken. What, have ye not houses to eat and to drink in? Or despise ye the church of God, and shame them that have not? What shall I say to you? Shall I praise you in this? I praise you not. For I have received of the Lord that which also I delivered unto you, that the Lord Jesus, the same night in which he was betrayed, took bread. And when he had given thanks, he brake it, and said, Take, eat, this is my body which is broken for you. This do in remembrance of me. After the same manner also he took the cup when he had supped, saying, This cup is the New Testament in my blood. This do ye as oft as ye drink it in remembrance of me. For as often as ye eat this bread and drink this cup, ye do show the Lord's death till he come. Wherefore whosoever shall eat this bread, and drink this cup of the Lord unworthily, shall be guilty of the body and blood of the Lord. But let a man examine himself, and so let him eat of that bread and drink of that cup. For he that eateth and drinketh unworthily eateth and drinketh damnation to himself, not discerning the Lord's body. For this cause many are weak and sickly among you, and many sleep. For if we would judge ourselves, we should not be judged. But when we are judged, we are chastened of the Lord, that we should not be condemned with the world. Wherefore, my brethren, when ye come together to eat, tarry one for another. And if any man hunger, let him eat at home, that ye come not together unto condemnation. And the rest will I set in order when I come.
Okay, just let everybody know the queue is open. If anybody has a question or a comment or anything to offer, star 6 and a 1 if you're on a phone. And if you're on an app or browser, should be a button to get in. Jan, do we have any questions tonight?
No, John, we do not have any questions at all tonight.
Okay.
What is it?
All right. Again, if anybody has anything, get into the queue. Last week, let's see, let me move this out of the way here. Last week, I filed papers on the president. It was and his cabinet. It's an extraordinary presentment to the President Trump and his cabinet. We started reading this. We did read part of this a couple of weeks ago, and back then it was 8 pages long. Now it's turned out to be 16 pages and an attachment, so 17 pages altogether. And we did start reading some of it last week. I don't think we're going to read any of it tonight, but I do want to let people know that it's available for download. You can read this extraordinary presentment. Again, it's right on our front page. Right here it says Extraordinary Presentment to President Trump. Now we've sent some other papers to him also. I probably should get up here and put dates on this, on the end of these papers, so that people can know, when these were actually filed. I'm going to be working on another one, and I'm going to focus in on the bar. Probably. I don't know. We'll see. But once I put it together, we'll read it in the next couple of weeks and then see once about sending it out. Also, you can find this also up on our Rumble page. And let's see if we go back here a bit. Okay, yeah, on our Rumble page is Extraordinary Presentment to President Trump. So this has been read and videotaped and put up online. So we have that also. So I suggest people maybe read that. And again, I don't think we're going to play any of it tonight unless we don't have any questions. And maybe we'll play some parts that I hadn't played before. I'll read through parts that I haven't read through before. Let me see if anybody's in the queue. Well, nobody in the queue right now. Again, star 6 and a 1. If you're on a phone, app, or browser, should be a button. Okay, we do have one person in, and hopefully we'll get some conversation going. John, looks like, John, what state you're from, John? Let me unmute you. Okay, you're unmuted. What state you're from, John?
Maryland.
John from Maryland, you got the mic. Go right ahead.
Yes, I'm very interested in this paper that you filed against the president and his cabinet, and I would like to know what your expectation is that it will be responded to. Do we have any power to force them to respond to it? And all, maybe start by saying, what is the goal of filing this thing?
Well, we're trying to open up our courts of justice. They've been closed for quite some time. They closed them through the Rules Enabling Act of 1934. And in 1938, the United States Supreme Court, which ultimately those rules were written, they were actually written by the bar, and it totally destroyed our courts. So that's what this paper is about. I don't know if you're familiar with us and what we've been doing, that we had brought together the Unified United States Common Law Grand Jury, and we've written this paper from that perspective. So it's from the Unified United States Common Law Grand Jury as an extraordinary presentment to President Donald J. Trump and his cabinet concerning Article 3, Section 2, which states that the judicial power shall extend to all cases in law and equity. And so we're trying to get this reinstated. We've been sending papers to President Trump for a while on various subjects. We've also sent some papers to the Supreme Court and to the federal judiciary and others, mostly trying to educate, trying to get our courts of record open. We did, I believe, through the Supreme Court, we did some demands on them. With President Trump, we're really working to try to educate President Trump concerning the law and the problems that has arisen from the Rules Enabling Act. When we put this paper together, I did a little research on how many lawyers. I don't remember exactly. I'm just kind of reading through here to see how many lawyers are in his administration and how many lawyers are in Congress. And it's quite a few. I can't find it right at the moment, but it is written in this paper that, how many lawyers are around Trump. Lawyers don't understand the common law, natural law. They've never been taught it. They have been taught that we're under civil law. They have been taught that common law is trial court decisions, which is really insane. A lot of really bad trial court decisions. They have no real power or authority. They're appealable. So again, they really have no standing as far as in a decision. It could be appealed. They could be overturned. But nevertheless, they have no power or authority over the people from the perspective that they're coming from, because they're coming from a civil law court. We're under law and equity. Equity, of course, is legislative law, but it is legislative law under the authority of the rules of common law, and that makes it very different than anything else that might be called civil law. Now, civil law really is for the purpose of controlling people. It's municipality law. It's also called Roman law. They refer to as Roman law. They believe that this is what they're taught in bar schools. They believe that we are fashioned under Rome, whereas the fact of the matter, we are fashioned under Israel, 4000 BC, and we're under natural law, laws of nature and of nature's God. We're not under man's law. So when they say that the common law is trial court decisions, well, that makes it man's law, and that's kind of self-serving also, because they can get a lot of cases that they can create and make sure it goes their way and start using that as law. And that is exactly what they have been doing for many, many years now. So our purpose, again, is to try to get our courts of justice open. We're trying to educate those who are not lawyers, okay? It's going to be pretty difficult to educate people who are lawyers. They're true believers in the process and the procedures that are set up right now. And it's very difficult to kind of sway them to even consider to look at what we're talking about. So we're looking, hopefully, Trump is not a lawyer per se, and there are quite a few people in his cabinet that are not lawyers, and there are also people in Congress that are not lawyers. We haven't sent these papers to Congress. I'm thinking maybe we might send some copies to a few congressmen and a few senators, but we'll see where that goes maybe. But again, if we can reach one person, just one person, to be educated, because people are not educated in this. They don't even know what common law is, and they don't understand the rules and the Rules Enabling Act. I mean, some people do, but very, very few. People really have not been taught civics. They haven't been taught the Constitution. They're totally ignorant to our founding fathers and who they really were, and who we are as a people. People seem to have bits and pieces of this, but most people are not educated, and this is the problem. Because Jefferson said, if a people expect to be ignorant and free, they expect what never was and never will be. And of course, the purpose of National Liberty Alliance is to educate the people. And we'd like to get some textbooks into the schools. We'd like to put books together in order to educate from K through 12. When a child comes out of school, they should understand who we are. They should know that we're a Christian nation. They should know how to enter into a court and take care of their own business. It's an unalienable right to have access into a court of justice. And on top of that, the only individual that has the authority from the state to be in the court, other than lawyers, of course, but is really a magistrate and no judge. Because judges don't have any authority to make any summary decisions or any decisions at all in a common law court, in a court of record. That's up to the people, the jury, to make the decision. And they have to be properly informed in order to be a good jury and to be able to really be liberated to understand their true powers and authorities. We the people wrote the law. We're the lawmakers. We wrote the Constitution. We ordained and established the Constitution for them to be obedient. We, the people, also wrote the Declaration of Independence. Now, of course, it was the Founding Fathers that did it, and they did it for themselves and their posterity. But it does come from we, the people. We've given the Congress the authority to write we gave Congress 18 powers. And they're not to write law outside of those 18 powers. and those laws that they're to write is called equity, and equity is supposed to be under the rules of common law. So even that falls under common law. If it's repugnant to the common law, it's null and void, whatever law they write. That's why the people have that power and authority to negate anything, the power to negate any law that they might bring up in a court of law. Now, equity is only for people who are working for the government agency, or for people who are working in the state commercial activities. At least that's federal law. Yeah, go right ahead.
So I'm aware of the fact that there is a federal and state court systems and grand juries are, either federal or county, actually. Is this intended to do anything at the county level? And the reason I'm asking that question is that I have come to believe that since elections are run at the county level, President Trump's pardon of Tina Peters was deemed not, he didn't have jurisdiction to do that. So that led me to believe that the county grand jury is the ideal way to prosecute, to investigate and prosecute election fraud.
Well, that is true. Every county has a state court within it. For instance, here in New York, we call our state courts, they're all court of records, but we call our courts Supreme Courts. Okay, that is the state court. And so we have, for instance, the Supreme Court in Dutchess County, which is where I live, or Supreme Court in Orange County or Ulster County, or whatever other county in New York. Same thing with every state. So you are correct in that. Now, it is true that they have federal juries, and I'm not familiar anywhere where I could read that there's any authority to have a federal grand jury. The people have to be chosen from within the county, and they probably do choose them because, again, The trial, if the state is bringing a case against someone and they're going to run a trial, then if a person is being charged with some criminal thing, then it has to be in the place where the crime was committed. So it has to be within the county, or at least within the state. I'm not too sure whether they really stick to that point of view that it's from the county. But it should be from the county. You know, it's the jury of the peers of the individual that's being charged with whatever the case may be. One of the things we're working on is trying to get administrators for the grand jury in every county in America. There are 3,134 counties. We're looking to get, an administration for the grand jury. We're looking to put 3 to 4 people in power and authority in every county, and disconnect them from the court. Although they'd be working out of the court, they're not subject to the court. They're free and independent because we are the people. We're the lawmakers. We are the ones who ordained and established the Constitution for them to be obedient to. So when a federal court wants to go after someone in a crime, then they should, from everything that I can see, because again, I haven't seen anywhere where there's any authority for a federal grand jury. All they need to do is go to the county where there already is a grand jury. Now, administrators of the grand jury are people that would orientate the grand jury, empower them properly, make sure that they understand their powers and authorities and so on, and also to be able to give them the powers and the authorities to investigate on their own as far as they want to take things. And even to the point of visiting maybe a state office or a federal office and look into information and ask questions, and the administrators would clear the way for that in order for them to do their investigation. And they can bring in their own cases, People should have access to the jury. I mean, if it's a state jury and it's a situation where there's a crime, really people should be taking that information to the sheriff. The sheriff should look at that and do some further investigation to gather evidence, and if he thinks he has enough to bring it to the jury, then he should be bringing it to the jury. But that doesn't take away from the people in certain cases to be able to get access to the grand jury. And that would be the job of the administrators right now. And the administrators would be no bar attorneys should ever be an administrator. People have to have a certain amount of knowledge. We do teach that knowledge with different courses for people to take these positions. These positions will be paid positions once we can get into the courts and take power back to the people in every county, that is, of course. And so it would be a paid position. So instead of paying bar attorneys, which probably charge an arm and a leg, and there's probably a lot of money that is put into the grand jury processes in every county. And so I think the people can run it a lot cheaper. Of course, they'd run it more justly, and this is what we've been working on for quite some time. Again, to get the people into this. So right now, of course, lawyers are orientating the juries. They're controlling the juries, both grand and petit juries. And that's a problem because they teach them that they don't have the powers that they really do have. So it's an uphill battle. But our key thing here is to educate the president, particularly, and other people within his administration. And again, if all we need to do is really all we need is one person. We sent this paper to 23 individuals. I think it's 22 people that are in his cabinet, and the president is the 23rd. So there's 23 papers that we sent out to all of these people. Now, and again, I'm taking a guess, if I recall, about half of them are not lawyers, about half of them are lawyers. I think that's how the numbers went. I don't remember. But in any event, the people that we might have the best hope to really read this and realize that we have come far, far from the Constitution, that our courts truly are polluted, and we don't have courts of justice anymore, and we're controlled by the bar ultimately. They control everything. Bar attorneys, they're everywhere. I forget how many thousands of lawyers are in Washington, D.C. alone, but it's something like, I think if I recall, it's about a third of the lawyers in America are working in Washington, D.C., and that shows you the problem that we have. So again, we're looking to educate people, take control of these positions, be totally separated from the courts, and represent the people, and building committees of safety in every county, which would assist these administrators also, at least in situations where they have a problem with maybe an individual. The plan is to put 4 individuals that would be administrators, and 1 paralegal, which would also be an administrator, in order to assist in writing the necessary presentments or indictments or whatever the case may be. And just take back the courts. When we go back into history, the people actually ran the courts, in the sense that, again, as I said, judges are not permitted into a court of record, which is a court of justice. They can come in, all judges are magistrates. They can come in, they need to put their magistrate cap on, so to speak, and come in as a magistrate. And the purpose of the magistrate is to exercise and execute the will of the jury, not to make any summary decisions. They're to act as sort of a traffic cop to make sure everything goes into order. The case runs in an orderly fashion, but not to be, not to get involved in the case decisions at all. And they're not able also to, advise the jury on as far as their powers and their authorities or anything of that. That's up to the people to do that. And that's the way it used to be, and that's where we need to get it back to. Uphill battle, though. Anything else? Because there's no one else in the queue at the moment, so if you have anything else, and if any of the leadership up here that has anything to pipe in, feel free to do that.
I would like to say that I have come to believe that if we, and I agree totally that we need to get the lawyers out of it. The prosecutors, control grand jury process is way too much, and the people on the jury don't understand the power that they actually have. And if we could educate the public on this, and the big problem is that the public is, slothful and apathetic, and so we need to find a way to get this information to them in a powerful, fun way. And so it occurred to me that perhaps the way to do that is to do a mock grand jury, recorded on like YouTube or something, and then distribute it every place, to show people, what a grand jury investigation could actually look like, and how it could be used to actually hold corrupt government officials accountable, because they are not outside of the jurisdiction of the county grand jury.
Well, again, this is why we need to get administrators, and administrators need to be trained, and so that they can, again, bring the potential jurors up to par, so to speak, and to empower them, for them to understand, when a jury comes in and is going to maybe work for a week or so. I mean, generally speaking, jurors might work a couple of days 1 week and maybe a couple more days another week, depending on where it's at. You can't hold a jury open for many, many months. Although if you're in a county where there's not that many cases, you might have a jury that might be there for maybe 2 months, let's say, or 3 months. But out of the 2 or 3 months, they may only come together in cases maybe once a week or something. Or a couple of times a month, because you can't take people away from their work, for too long a time. So then you have to replace the jury, sort of get new people in. If you're in a place like New York City, you probably have many juries operating. There's 5 counties in New York City, and there's a lot of things going on down there. So you probably need more in a situation like that. You probably need maybe twice the amount of people for orientation as far as being administrators. and for the juries, whether it be a grand jury or a trial jury. So they would have, they would then again call the juries down in New York City, for instance. Like I said, you might have 3 or 4 or 5 or 6 juries actually running all the time. And down there they might actually, work for a solid week or two and then be let go, and a new group of people would replace that particular grand jury. But every time a grand jury comes in to power and authority, they need to be orientated. And so you got 1 day for orientation. The jury is called, they come in. Once the jury is selected, then you get to orientate the jury. You have 6 to 8 hours. They come in for that purpose. And the other thing is we need to pay jurists more. I mean, it's a ridiculous amount of money that they give the jurists when they come into the jury. And you take all the money that they spend on lawyers just to come in to orientate the jury, and of course they do it under civil law and not natural law. We're under natural law. So we have to take all this back. And again, these administrative positions are a full-time job. People would actually work out of the courthouse, but they would be separated from the judicial system. The only involvement that the court system would have is in order for them to take their oaths, the judge would give them an oath, and then once they take their oaths, then that's it. They don't see the judge no more. It's all up. The judge doesn't have to give them any instructions. We, of course, written handbooks for this purpose. If you go to our website at Start a Committee of Safety, and you highlight that, you come down to handbooks, videos, and tools. That's the page I'm on right now. This first group of videos these are short videos, maybe 20 minutes. I think the longest one is a half hour. Some are even shorter than 20 minutes. But in any event, it's an introduction to each of the committee involvement on a committee of safety within a county. And but underneath that, we have a lot of handbooks that could be downloaded. We have, for instance, we have handbooks for the grand jury and for the trial jury. We can run them off and print them here in PDF form, or people can actually go to, let me see if I can get this, open the link in the tab. Okay, people can, actually at some point, we could probably get these brought out pretty cheap. Right now, you buy one at a time, and we got these books up on Amazon. But people should get a pocket handbook. If it's a grand jury, they should get a pocket handbook for a grand jury. If it is a trial jury, they should get a pocket handbook for a trial jury. And basically, that handbook is the orientation for them. We'll put some videos together, maybe some PowerPoints, and give it some visuals. I did start working on some of that stuff, but I haven't finished it yet. I got time because we're not ready to move into that. But we can put it together pretty quickly. But we'll put together a whole plan on how to orientate the jury, and again, pretty much the handbook. And then each jurist would have a handbook for reference, and they would keep that handbook. And this is a way to educate the people, okay, at the same time. But you are right. The problem is the people are complacent. We need to educate the people. If a people expect to be ignorant and free, Thomas Jefferson said that they expect what never was and never going to be. So if people don't know the law, the law is, our heritage is in the law. So you have to know the law in order to know your heritage, in order to know your powers and your authorities. And it's not difficult. I mean, the common law is common sense, and you work from the heart. God wrote His laws into our hearts. We're under God's laws. We know when a wrongdoing has been done. And so, again, people have to learn these things, but it's tough to get people to really sit down and read a book anymore these days. I think technology has really injured people. They read a lot of garbage, a lot of tweets and different things like that. And people don't sit down and read books anymore. At least I think a lot of people don't anyway. Now, we need to get this education back into schools. We do need to get the people educated. But it's up to the people to and we offer a complete education here, by the way. We offer a lot of courses, and most of our courses are free. A couple of our courses require people to be a premier member in order to take 2 of the courses. And a premier member is someone who is given $5 a month or more. In other words, supporting what we're doing here. I know times are tough, and if someone really is that broke and they can't afford the $5 a month, which is only a cup of coffee and a roll and butter or something once a month, but if they really can't afford it, we'll let them in for free, because really our purpose here is to educate the people. We're not here to make money, but we do need money to keep the lights on and keep things going. And in order to really get out to the people, is we need to hit critical mass. And that is what we're looking to do. Anybody who thinks that they can help us figure a way to get critical mass out there, pipe in and let us know. But we do need some advice on that, because we have to get the word out. We got almost 12,000 members, but really we need critical mass. We need to get out to 1 million people and more. And out of that, you get a small percentage of people that really get active and really get involved and really want to get educated. But everybody should be educated to a degree. And as I said, our heritage is in the law, and our inheritance is liberty. And we need to know what our liberty is. We need to know what powers and authorities we've given to these people that we put into office. Because if we don't, as a matter of fact, it turns out that most people in office don't even know the Constitution. Maybe lawyers do to some degree, but they really don't, because they're taught from the civil law perspective or point of view, and not from a natural law or a common law point of view. And that destroys everything once they're into the civil law process. But we do have to get rid of lawyers. We have to get rid of the Bar Association. That has got to go. It's hard to get that message out to people, especially to lawyers. But people don't understand this, and they may think that's kind of radical. But our founding fathers didn't think it was radical, because they wrote the original 13th Amendment, which disappeared. But there was a 13th Amendment, and if I recall, it was in, I think it was 1809 or something like that. I forget the date. But it was passed, the 13th Amendment, and the 13th Amendment prevented anyone that had a title of honor from holding any position of honor. And all bar attorneys are esquires. That's a title of honor. And they have, an allegiance. They take an oath, a lawyer's oath, and they have an allegiance ultimately to the bar. The bar, giveth, and the bar taketh away. And we have to break that whole system, and we have to get rid of this insanity that we're under civil law. And the only way to accomplish that is to execute the original 13th Amendment. Now, in 1860s, somewhere around there, the 13th Amendment sort of just disappeared. I mean, the people didn't even realize it. This is how bad it is, okay? But the 13th Amendment just disappeared, and they came up with a new 13th Amendment. And we need to fix that problem. But it is an uphill battle for the minds of the people that are in power. And one of the things that people can do is to not only learn for themselves the Constitution, learn for themselves civics, learn for themselves who we are as a people and natural law, and how the court system works. Everyone should generally know how to do it, and some people should absolutely know how to walk into a court and take control and write papers and file whatever court cases they want to file, or answer whatever court case that they might need to answer. They should be able to take care of their own business. It's an unalienable right, the right to a court of justice. It's our courts, and they have stolen it from us, and we need to resurrect it.
May I ask you what the original 13th Amendment was? Because there is one in there now.
Yes, the 13th Amendment that they have now, and the 14th Amendment. Let me see, we should have a copy of that up here, I'm sure. Hang on a minute. Oh, I'm on the wrong page. Hold on. Handbooks. Jan, Eric, or anybody out there, do you remember where, or do you know that you've seen the original 13th Amendment? I would imagine.
remember you used to include it. You used to include it with the Constitution course, but then the Constitution course was combined with something else. I mean, this is years ago at this point, but I don't know where it is on the website now. But you have it. I think GR has it at Reclaiming the Republic, but we have it somewhere. We've got it.
I'm looking for it. I know we have it up on the website. It's been a while since I've looked at it. I'd like to. It's a short one, so we should be able to read it quite quickly. Did we have it in our course?
Yeah, we had it in the.
We may have had it in our course.
Yeah, we used to have it in the Constitution course, but remember that got changed around, and I don't remember what happened, but I think it got combined with another course. But you got it at the end of it, like it was included. It was included at the end of it, and you got to have a copy. But that was for me a couple of computers ago. I don't think I even have it anymore. But it's great stuff. It had a lot of material, and it basically shows the receipts of it being ratified. And again, GR has it at Reclaiming the Republic, I think.
All right, well, I have some information here. This is a paper that we do have. It's a memorandum, and we do I'm pretty sure in this memorandum we do have the verbiage for the original 13th Amendment. And let's see, the original 13th Amendment, this article of amendment ratified in 1819 and which just disappeared in 1876 added an enforceable strict penalty. Example, inability to hold office and loss of citizenship for violations of the already existing constitutional prohibition in Article 1, Section 9, Clause 8 on titles of nobility. Our founding fathers wrote the 13th Amendment because they failed to realize, and I don't know how they did this, but they made an error in it. In Article 1, Section 9, Clause 8, it talks about titles of nobility, but it doesn't talk about titles of honor, because an esquire is not a title of nobility. A title of nobility, that is inherited. If you have a position of nobility, your children inherit that position of nobility. With titles of honor, it would be like an esquire or a knight. That's not, you don't pass that on to your children. But here it is. I'll read the Article 13 ratified in 1819. And it reads as follows. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, and then I have in parentheses here, bar lawyers have the title of high honor above gentleman and below the knight called esquire. So let me go back. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. So that's what the 13th Amendment read. It's very short, and so when it disappeared, and we don't know exactly when it disappeared, but we know when the 13th Amendment that we understand kind of resurrected or came into being. That happened in, let's see, I'll see if I can get a date here. 13th Amendment was the 12th Amendment was ratified. Let's see, June 12th. We want the 13th Amendment, and that was 1804. 13th Amendment was ratified December 6th, 1865. So when they went to ratify this 13th Amendment, which talks about slavery, we read, neither slavery nor involuntary servitude, except as a punishment for a crime, whereof the parties shall have been duly convicted, shall exist within the United States or in any place subject to their jurisdiction. And then there was a Section 2, Congress shall have the power to enforce this article by appropriate legislation. So it's pretty short. And the 14th Amendment came out pretty much the same time. It was a couple of, let's see, the 13th Amendment ratified December 6, 1865. 14 was 1868. But what they should, the way we can repair this, if we can get these people educated and understand the problem and the situation, the way we can repair this is we can pull the 13th and the 14th Amendment, bring them together as the 14th Amendment, and then bring the original 13th Amendment in view as the 13th Amendment. And that's how we can repair this problem. But again, you know, these people have been working for a long time. The revolution has never really ended. We've been at war, really, for quite some time, a couple of 100 years, 250 years, and hopefully it's coming to an end now with Trump in office.
So, John, office of trust or profit. So that means they can't be in government and they can't even own their own business. I'm pretty sure that's what that means.
Yeah,
and
that probably does. I'd have to think about that, but yeah, that makes sense.
Yeah, they'd have to work for someone else at best, and they'd be a resident alien in the nation they were born in.
Right, and if they're not citizens of the United States, they can be kicked out.
Absolutely, 100%. Yeah, goodbye to all of them that were not born here, and the rest will be resident aliens who cannot hold office and cannot have their own business. And if that's the worst that happens to them, they should consider themselves really lucky, I think. But I don't think we need to be any more stern than that. That's the law of the land right there. That should do it. That would be strict enough, I would say, in my opinion. And also, the thing about what we got with the Constitution course, if I remember correctly, was these notes that you have down here of the various states. I don't think you had it for every state that you have listed there, but you had a lot of states where you actually had, like, you had shots, photos of the ratification of the original 13th Amendment. So you probably have that somewhere on one of your computers or hard drive.
This would be in the memorandum. Let me just take a quick look, because those papers you're talking about, here they are right now. So we do have all of the documentation showing that it has passed through the whole process, and so, you know, it's slam dunk. But you know, but these people don't believe it, and you know, everything we do here at National Liberty Alliance, you know, the books we've written, the papers we write, everything has footnotes. So we give our authorities. And we make copies of any kind of documentation that might be necessary if we're, you know, building something in a memorandum for, like in this case, we did a memorandum on the 13th Amendment, and it's 19 pages, okay? So anybody that might want to get a hold of this, you can find this under Education Starts Here, come down into Law, and then over to Court Forms and Process. And then you will find a list of memorandums. Also, you'll find this memorandum in the book, Government by Consent, that we've written. But you'll find it on this page here. You'll see Memorandum Amendment 13. And I think we have it in PDF and we have it in MS Word, so people can download either one. And so this is what it looks like. This is the paper, and we filed these with the courts. We filed many hundreds of papers with the courts. Nothing goes anywhere. They do a lot of ignoring us. They weren't sending our papers back, but they weren't responding to them either. The court, you know, they just don't want to hear anything. And lawyers don't want to listen. And that is the problem that we do have. But again, if we can get the attention of one person within Trump's administration that would read this and realize what's being said here, then you know, they would feel a necessity to really open the minds of the other people within Trump administration, because this is a real serious problem, and I think this paper defines the problem and the solution very clearly in the 17-page paper to President Trump and the cabinet. Okay, we got some other people in the queue. Anything else, John?
That's it for now. Thanks.
Okay, thanks for the call. Okay, let's take next person in the queue. And again, if anybody else wants to get into the queue, it's a *6 and 1 if you're on a phone, and there should be a button there if you're on an app or browser. Next person is, mic has been open. ENDAM, is that Endam? How do you pronounce your first name and what state you're from?
Oh, it's Endam.
Endam. What state you're from?
Yes. I'm from Maryland.
Okay, Maryland. Endam.
Yes.
Go
And
right ahead.
give me I want to ask the question on behalf of my brother.
Okay.
Can you, okay, just give me a sec. Let me get myself together, please.
Okay.
I'm fine. I found it. I'm fine. Okay, he actually is presently he's currently in jail, and he sent this question for me to ask. He said he filed a common law. That he filed a common law 28 USC 2243, writ of habeas corpus,
Yep.
and an order to show cause and memorandums after studying court access by Darish with the U.S. District Court of Maryland, Greenbelt. He filed it in Greenbelt. And the petition was docketed on December 29, 2025, and the respondents failed to timely respond. He proceeded to file an affidavit of default accompanied by a petition for default judgment pursuant of the FRCP 55, 58, and 28, requesting immediate release from detention, which he never heard from the court.
Right.
And
Yeah, the problem is the court is corrupt, they're evil, and I don't say that lightly. These people, first of all, they have been taught, again, civil law. They truly believe we are fashioned under Rome, that we're under civil law, and that we are not a Christian nation. They may accept the fact that a lot of people in the nation is Christian, but they don't accept the fact that really we are a Christian nation, period. That the king of our court is Jesus Christ, and that so therefore the jury is the king's bench, and so the jury that is to hear a case is to answer to God Himself. We put together an oath also and to the governor of the universe that anybody that's working for the administration, for the jurists, to have to take that oath. And we should probably give that oath also to the jurists themselves. But jurors are to follow their heart, okay, and rule with common sense, because that's as simple as common law gets. You listen to the facts, you apply common sense, and you work from your heart, because God wrote the laws in our heart. We know when someone has been injured, we know that someone might need to be restored, and we can figure out how to restore that person. That's what the job of the jury is. Or, of course, on the other side of the coin is maybe being convicted of something, finding him guilty of something. Well, the jury not only gets to decide the facts, they get to decide the law, because we are the lawmakers, and we are not held by statutes. And so they get to decide the law also, and they also get to decide the punishment, which always should be with an eye on restitution, not necessarily jail. We seem to put too many people in jail that don't need to be in jail. You know, violent people might need to be in jail, but generally most crimes don't need to be in jail. You know, part of bringing the person back into society again as a good individual, hopefully, you know, the restoration in the process of them restoring the person that they injured, they themselves can become restored themselves, and come with a whole new perspective and appreciation, and hopefully be a good citizen themselves as time goes on. But that's how we fix the problem. Okay, putting people in jail doesn't answer the problem. And when people are punished by being put in jail, and maybe they're hit with a fine or something, you know, it's a sick situation, because the person who is injured, they get nothing, absolutely nothing. Okay, even the penalty maybe of a fine goes into the pockets of these people in the judiciary. It maybe goes into their retirement fund, or maybe literally sometimes into their pockets. I don't know. The way we're seeing things going on right now, there's a lot of corruption, a lot of people being paid off, all kinds of sick money, and so I wouldn't doubt that this money is going into the pockets of judges and different people. But that's a system that is alien to who we are as a people. We need to restore our courts of justice.
Yeah, so do you know any reason why? Because he filed a 2243,
Yeah.
but it was recharacterized and it was recharacterized and put in a 2255 motion. So
Okay, well, I'm not too sure what that kind of a motion is, because that's the civil law side of things. We do understand to some degree their rules, and and looking at their rules, a lot of their rules, what they have done is they have taken away the rights of the people. First of all, in their rules, Rule 2, which the bar wrote, and the United States Supreme Court claims and approved it, and it became the rules in 1938 of the court, and they trashed the rules of common law and put in their own rules. Now, what it did, it empowered them, and it took power away from the people. We have particular writs of power to the sovereign. A writ of error, for instance. We have the power and the authority to write a writ of error. Well, in their rules, they abrogated that writ. They abrogated about 6 writs that were the power of the people, okay? And they also abrogated the common law. Rule 2 combined civil law and common law together, and then under the title, they combined equity and law. I'm sorry, equity and common law together, and they called it civil law. So they bastardized the entire system. They changed our entire law system, and they got away with it because we, the people, are not paying attention. We're not educated enough, okay? And we need to be educated. It was the job of government to give us a good education, and the worst thing in the world that could have happened, and it did happen, is centralizing the education to the federal government. Now, Trump broke that up. He's pushing it back to the states, and the people need to get more involved locally in their own school districts to make decisions and demand obedience to what we want our children to learn. And that's where it needs to be. But, we can teach our children and get good education into the schools, but, the people who have come out of education, were working jobs and doing things, we don't have this proper education. We need to find time to educate ourselves. And again, you don't have to be very articulate and understanding of all these things, but if you go through the courses, at least you have a framework in your mind, and you can relate and see the problems and work to correct the problems. Now, coming to a deeper understanding and spending time, maybe, for instance, being able to go into courts and take care of your own cases, it takes more time, more involved. But we offer everything people need in order to accomplish all those goals. Now, as far as these other papers, we have written many habeas corpuses ourselves, and we've only had one habeas corpus that actually went through, and even that's questionable. The person was released. I don't know what they did on the record with that habeas corpus. But other than that, we've written maybe 100 habeas corpuses, and they ignore us, okay? They claim or think that we don't have the power or the authority, and that's how far it has come. The show cause, it depends on how you come in with a show cause, and if it's a criminal case, it probably came in correct anyway. I presume he did it correctly. But they should have answered. If he's missing, for instance, if he doesn't put a summons on top when he files the papers, they'll just ignore it. They won't even respond to it. So maybe he's missing something, and they're just not responding. The other thing is, did they put a lawyer onto them? Did they require him to have a lawyer and gave him a lawyer?
No.
So does he have a lawyer?
No.
So he doesn't want a lawyer, and so he didn't accept a lawyer. I'm sure they offered him one, and he didn't accept it. Correct?
Yeah, he said they are not he said he had one, but the lawyer was not doing a great job, and he was like, no, he was just going to follow up his things himself.
Yeah, they're all
Yeah.
problematic, these people, because they don't want to
Yeah.
go according to the real law. You see, when a lawyer goes into a court, they claim to have a license, okay, and they claim you can't come in without that license. But there is no such thing as a license to practice law. It's just really a union card is what they have. They're part of the bar association. And so since they're under civil law and they created the whole system, you can't go into their system, so they claim. They don't really explain it to you, but what their thinking or their logic is that you can't come in because you don't have a union card, you didn't go through school and learn what we know, and you don't understand the procedures and processes that we know, and you don't know the things you can't do, and you have to, acknowledge certain things about the power and the authority of the court and all this other stuff. But you can get in there on a federal level. There is a statute written concerning what's called the next friend, and to come in as a next friend, you can not only represent yourself, you could represent a group. Okay, and so you can come in as a next friend, and you can open a court of record when doing that. They kind of accept that if you do, they kind of accept that. If
I
you
think
come
that,
in,
that is what he did. He filed the 2243 writ of habeas corpus through a next friend, including an order to show cause and memorandums after studying
right.
court
Well, again, first of all, they're ignoring him because they want to ignore him, and they don't want to, and he's not being obedient to them. They think that they're the masters, and we work for them or we're slave to them, and they don't like the idea that he's bucking the system because he's coming in with all this common law or natural law that they don't like, and they get away with it because no one's watching, and uh,
Yeah.
and so they get away with this. What we are doing, though, is we're trying to get to work with the Trump administration to focus in on getting our courts of records back into the federal courts. Okay, if we can get courts of record open, which is a common law court, it's a court that goes according to the common law or the natural law, and if we can get courts of records in the federal courts, then we can take that right down and require the states to do the same. And if they refuse to do it, we can move that case into federal court for cause. And the federal court, it would be their duty to enforce the law and make them be obedient to opening up courts of justice. So that is kind of a plan on how we're trying to get things going. But yeah, look, it's a major problem with these people. They don't like people coming in and bringing in the common law, the natural law. They just don't like it. And, it's a problem to them because it'll reveal, as time goes on, natural law will reveal their corruption. And that's what they're concerned with, and that's what they're afraid of. So it's corruption. That's what it is. And
Yes.
it's an evil thing.
So, with your experience, what suggestions do you think, or what strategy do you suggest that he can
Well,
do
has
to
he been
help him?
convicted? Has he been convicted? Did they
He
make any
has,
kind of... Okay,
yes, he has been convicted.
was he indicted?
Uh,
A lot of
yeah,
people are convicted without an indictment.
I'm not sure. I
See,
don't
if
know.
he hasn't been indicted by a grand jury, then the whole thing is fraud and he should be released.
No, it
Because
wasn't a grand jury. It was just a judge that gave the sentence. It
I understand, and again, that also is a violation of right under the natural law because the judge can't give the sentence. That's up to the jury. They won't buy that. They don't like that because they've stolen the powers from the people, and they've been used to having it so long, and they don't want to give it up. And look at their whole system is corrupt. All the lawyers that I've ever met, I get bad taste about them, with the exception of maybe two. Okay, there are two lawyers, and I've known a lot of lawyers, and dealt with a lot of lawyers in courts in different places. But they make me sick to my stomach. They really do. They're nasty. They're all about money.
yeah, yeah.
And they're just evil. I'll tell you, they don't realize how evil they are, but they've been trained to be evil. They are the minions of the New World Order. They are the reason America is in trouble, because it's the lawyers that have created this whole system. It is the lawyers that really got together to push the focus towards the party bosses. It's the lawyers that put together and push the focus of a lot of things. You know, our education. They control the education. They control the courts. They control the rules of the courts. They control the laws. And the whole thing really is destructive to the people while they're lining their pockets, you know. It's amazing. And you can't get a lawyer to go in properly into a court. They can't do it because they'd lose their bar license and they wouldn't be able to practice law anymore. So they won't go in and represent someone under natural law. And first of all, they have to come to understand and realize that natural law is the law of the land. It's in the Constitution. It's the law of the land, and so first of all, they got to get educated in that, and come to a realization that we're under God's law and not man's law, and that's the beginning. Now, once they get to that point, and I do know a lawyer that did get to that point, and he actually was put in jail on one occasion because he tried to bring forward the common law. And he's still practicing law, but it's a major problem for him.
Okay, so he was thinking that he wanted to go ahead and prepare an affidavit notice of objection and wait
was he convicted in a state court or a federal court?
Federal.
Federal court, okay. Yeah, look, it's really a tough deal.
I think it's a state court, but he's in the federal prison. That's where he
so
is.
it's a federal court if he's in a federal
court.
prison.
Yes.
You see, if he was convicted in a state court, he might be able to open up and move it into federal court for cause and have the case thrown out under certain conditions that there are a lot of conditions that could be thrown out on. But then yet, the federal judge would have to uphold the real law also. So it becomes another problem, and that's a rarity. It's happened on one or two occasions that I'm aware of, but it's a real rarity. The only positive news I can give you is that if we can get our federal courts back, which we're working diligently to do, if we can get our federal courts back, then we'll get our state courts not long after that also. But that's when people can now go into the courts and get justice, because they can move their cases into courts of justice. And they'd have every right to be able to reopen their case and do that because they were tried under the civil law and not under the natural law. So, but again, we have to get courts of record open again. Courts of records are courts of justice. They're common law courts. So we need to reopen those courts. And as I was talking a little earlier, we're looking for critical mass, because in order for us here at National Liberty Alliance to achieve the goals, all the goals, we have lots of goals, and we've put a lot of plans together. We've got lots of paperwork on different things and books and handbooks, and so we're very well organized on the education side of things and the process and procedure side of things. But what we need though is critical mass so that we can go professional. Because we're all volunteers here. One of our members said to me one time, we got two good news. How do you put it? Let me think. I forget how it was put, but basically the point is that the
good news and bad news, John.
Is that what it was? Okay, yeah, good news and bad news. Yeah, the good news is that we are volunteers. The bad news is we're volunteers. You see, in order to get things done, people need to be working full time, 40 hours a week, and they need to get paid for that. You can't expect anyone that's volunteering, to work 40 hours a week and get diligently involved in the things that they need to get diligently involved in. So if we can get, critical mass, then we might be able to get enough money to be able to support a professional process here. But until then, it's very slow moving.
Wow.
If anybody's got some deep pockets, here's a good place to put some money trying to get our courts of justice back open, And to get critical mass, it's a difficult thing. I'm really pushing lately on Rumble. I'm pushing lately on YouTube. I joined X, trying to get information out there. But it's an uphill battle and time consuming, trying to get the attention of people, to get people involved, and potentially maybe find some people with deep pockets who would like to really, help us financially to turn professional. But if we had, a million people involved, we'd get a high percentage of them giving us $5 a month. Some people more, and that in itself could be a huge amount of money to be able to pay salaries and move professionally. But again, that's the problem we have.
Okay, thank you.
All right. Well, look, the best I can say is hopefully we get courts of justice open and he'd have the ability to get his case into the court and they'd have to obey. And that could happen because, if we get if we get the administrators into every court in the United States, that'll take some time. People need to become educated, but they could be working while they're being educated because we'll do a better job than lawyers will do in any event anyway. But at some point, the administrators working for the grand jury could be of an assistance in some of these cases of wrongdoing where the people were tried in a civil law court when they had, a Seventh Amendment right to be able to be tried in a court of law. And nobody's being tried in a court of law these days. So the whole process is unlawful, illegal, and repugnant to our Constitution. Okay, thanks, Edom.
Thank you too very much. Thank you.
Okay, take our next caller. And again, anybody wants to get into the queue, star 6 and a 1 if you're on a phone. App or browser should be a button there somewhere. So we only got a couple of people left in the queue, but let's go to the next person. It looks like Jan from, is that maybe Wisconsin? Let me unmute you. Okay, Jen, you got the mic. Is that from Wisconsin?
Yeah, Jennifer.
Yep, go right ahead.
Yeah, thanks. Like triple thanks. I'm listening to you a lot. I look forward to Monday evenings and try to join live so I have the gumption and guts to join the conversation. But in the meantime, signed up and paying my way as best I can. I understand you have to have at least $5 a month from each of us to reach out for that professionalism you're talking about. I was really struck by John's comments, the first caller,
right?
And he used the turn of phrase "mock jury," and of course, mock can be troublesome. There's
right.
nothing to mock there. If anything, it would be a noble jury enactment or a participative instructional practice of assembling. Not as the Committee of Safeties, although I back that entirely, but I'm on an entirely different front in the interest of critical mass. Do you recall when you were a kid and the school would say, well, there's going to be an assembly, capital A assembly, and it meant that all the grades went together into the gymnasium and there would be some sort of performance or lecture or something much more interesting than whatever was on the docket for classes that day. And it was potent because we were all together and it was extracurricular. It wasn't an athletic event or the band wasn't playing. It was somebody from outside coming in and saying, hey, listen to this. This is interesting and compelling and you could be a part of this. And sometimes they were jugglers or clowns. But the assembly, do you remember it? Was that?
Well, I don't recall anything like that when I went to school. I did go to a parochial school, and I was in school in the 50s and the 60s.
Okay, well, so I'm 70s and 80s public school, small town. The other word that comes to mind is something called a lyceum, Lyceum, a U.S. association providing inspirational lectures, concerts, entertainment. And the Lyceum circuit, maybe more so in the Midwest. I'm not sure geographically how this distributed, but out here, these were edifying gatherings that would tour, and people would participate. Skip the media events that are known as town halls, these sort of enactments of what a town hall might look like, but with a bunch of prescribed questioners and answerers, and instead of a live gathering of young people and old people and everybody in between. At in our town, it would be at the a combined building. We're an old town, Cornish mining town. And the Opera House, paired with the City Hall, paired with the Free Public Library, was a large building. And the idea was that public discourse would occur in that auditorium. Eventually it became vaudeville and a movie theater. But, that's a different sort of town hall when everybody comes and there's something interesting and educational and civic about what our role is, right? I'll yield. Go ahead.
Yeah, well, no. I want to add some things or respond to a few things, and we can continue with. But, look at one of the things we need is to get enough people to respond and go to something like that. What we're trying to do right now, which is kind of similar to what you're thinking, but it would be on a regular basis, on a monthly basis, where people would get involved in what's called the Committee of Safety. And the Committee of Safety really is the original Committeeman process, which has been politicized and controlled by party bosses. And we can thank our bar friends for all that, because they set that whole system up. They robbed the people of participating, truly participating in the political process. And so committeemen come in, and the only thing they get to do, they get to walk the papers. Okay. And they think they get a decision making in who they're going to put on the ballot, but that's really done by the party bosses. And so it's the criminal on the right or the criminal on the left that usually gets into power, and that's been the major problem. And so the committeemen the committeemen of today, which is part of the political process that they set up. It really just is out there as the slaves to walk the papers. You have to get enough petitions out there in order to get a person on a ballot. And so that's what committeemen do. But the committeemen originally had a lot more involvement than that. They were involved in all of the social activities within their counties. Whatever education was involved, as time went on, of course, you have an education committee. We have a political process committee. We have a judicial committee. And we have a militia committee. And then the general committee is everybody. And that's where we're working, to teach people how to open up a committee of safety, get involved, take back their schools, take back local government. And we could do this through a writ quo wanto, which, by the way, I just recently found out that writ quo, and most judges don't even know this, at least not on the state level, but on the federal level they do know this. But on the state level they don't seem to know it at all. They abrogated the writ quo wanto. But the writ quo wanto is a powerful paper which requires the person to respond by what authority they act. And if they don't respond within 3 days, they lose their office. And then anyone can claim that office. And if that office is going to be coming up for election within a year, then that person would hold that seat until the election takes place, and they can run for that position also to get elected. If it's more than that, then they have to run a special election to get someone into the seat. But that's how powerful a writ quo wanto is, and you can see why they didn't want that writ quo wanto. You can see why they abrogated it by rule. Now, they've made rules as powerful as laws. They apply their rules like laws. Rules are made to be broken ultimately. Look, a good rule is a good rule, a bad rule is a bad rule. Common sense rules what is a good rule and what is a bad rule. It's that simple, okay? But, this is the problem we have. They've stolen the whole process from us, and we need to get it back. So
Okay.
people on a committee of safety, people need to put some time. Look at we're in a nation with a great constitution and a court system set up as natural law, which again they stole. We need to get it back. But if we were to really exercise, first of all, if we actually knew the Constitution, that we could exercise the Constitution and see when they're breaking the authorities and powers we have when we put them into office, if we had that ability, and that's what we try to teach here, is that ability, and you exercise that through committees of safety, you can be able to take control of your congressman. Your federal senator should be from the states. That was out of the 17th Amendment, and that was repugnant to the whole Constitution because it destroyed the balance of power of the Constitution, the 17th Amendment. But in any event, you'd get to get involved in putting the right people into power, requiring that they know the Constitution. Most of them don't; they don't have a clue, and then you can hold their feet to the fire. And we can remove them through recall. We have if you have enough people in your group, 20, 30, 40, 50 people, and you should grow every month as time goes on. But, if you have enough people to walk the papers, you can recall pretty much anyone, at least on the county level and potentially to some degree on the state level. Like for instance, your state representative maybe, or the state senator, and even your congressman, because that's a limited area, and you'd have enough people to be able to walk the papers to recall them. That is to take them out of power if they're not obedient to the Committee of Safety. Now, all politicians, when a chairman talks from the committeeman process, which is the process they set up, which is a party boss. When a party boss, a chairman, county chairman, let's say, addresses someone on a level that they brought into power, by walking their petitions, and they want to discuss a situation to them and require them to do certain things, they will be obedient because they owe the ability of getting into that office by being put onto the ballot by that person. And that's why they'll be obedient. Now, if we, the people, take that back through the committees of safety, then the statutory process will eventually fall apart because why go there when you can go here and have real power? And also, over time, people that get involved in the committeeman process, at some point in time, they start to realize that they're just suckers. They're there to walk the papers, and they have no power, no authority at all. Their vote doesn't mean anything. They just make it look like it means something, but it doesn't. They want to get their puppets in that they want. So the people who stay usually for long periods of time usually are people that get involved, and they're kind of into the system, and, they're getting something out of it. Maybe they're getting a highway contract. Maybe they're a contractor and they get the highway contract. Different things like that. All these favors. It's a problem. We need to fix it.
It's a mockery.
Mm-hmm.
I hear you on all of those fronts. I cannot say to you right now that I'm involved with the Committee of Safety, although I have quite a bit of exposure to them because I served for a relatively short period of time in an official capacity with a different organization that is also driving the creation of committees of safety at a county level, such that a reinhabitation can occur. I'm not interested in that. I am interested in a government restored and returned of by and for the people. And so if in addition to what you're saying, there was a remedial, apolitical, not political mode of gathering, I guess concurrent with everything that you just talked about, that the Committee of Safety drives, and that ultimately the assembly of people drives.
Yeah, just so you know, we built this whole system without getting involved in politics. We get involved with the political process, right, which is putting people into power and taking people out of power, and then watching these people, making sure they're obedient to their oath that they've taken. But it's a lot more than that because we do the same thing at every level within the county and within the towns. And so we don't get involved in Republican or Democrat. We don't get involved. Parties are destructive. George Washington spent two-thirds of his farewell address talking about the problems with parties, political parties. They would be the destruction of this nation. Jefferson took a different view, and he said the judges would be the destruction of this nation. And guess what? They're both right. Yeah. And so, we are teaching people to do this without getting into politics. There's no look at what is the politics all about? It's debating and arguing, ultimately trying to get more and more power. The right wants to get more power, the left wants to get more power, and they do all these crazy things, and they put through some laws, statutes, and pass bills, and they do a lot of stuff. And I would say probably 90%, I don't think that's an exaggeration at all, 90% of the things they do are not constitutional. Okay? And if the people understood that, then they can prevent that from happening. One person can't fix the problem. United we stand and divided we fall. And that's why we're not just working on committees of safety within the counties of one state. We are working for committees of safety in all 3,134 counties. So you get a certain amount of counties that are empowered as committees of safety within a state. Now you can really get some power and authority on the state level and really do some heavy-duty, repairing of our government. And then, of course, you get other states are doing it. You get 2, 3, 4, 5, 10 states working together, again, on a certain problem or a situation. But we've created it in such a way to set the stage that they are free and independent committees of safety. National Liberty Alliance doesn't give any marching orders. We don't tell people what they need to do. We put the whole structure together for them. We give them a proper education, and we trust that they'd be able to take care of their own business, the people within their counties. And we set up things on the committees that you do have to open up and work with. As time goes on, you open up all these different committees. The Education Committee is extremely important. The Political Committee is important. The Judicial Committee is important. The Militia Committee is important. And so we've laid that all out, and we've put together all of the necessary paperwork in order to get this down. We created a charter, which is a framework for a charter. It's kind of all the basic stuff that really should be in your charter. But there's a lot more that the counties the people within the counties want to add into that, and they'll add into that as time goes on. We also put together resolutions, kind of a standard necessity of certain resolutions, and all of this paperwork really structures ourselves in such a way that we can work county to county, state to state, and we can operate in a way that is consistent and and just working together. But so we're not into the politics, and again, there's no need for political debates, all these political debates, because we've already addressed the issues. We've given them the powers and authorities. Again, we go back into Article 1. We've given them, I think it's Section 8. We've given them 18 powers. 17 powers, and the 18th power was to make laws for all those 17 powers. So anything outside of that authority, they have no business talking about it. Okay, they don't need to be debating our First Amendment and our Second Amendment or any of those things. That's none of their business. They need to be obedient to what we put together and just obey. That's it. So their job is to create proper law, constitutional, or shall I say natural law, as far as equity is concerned, to control government agencies and control, commercial activities on interstate commercial activities on the federal level. State has the same powers, But then we'd have a real government. But right now, we're in they try to make us a democracy. And the purpose of a democracy is to lead us into an oligarchy. We are already well set into as an oligarchy, but President Trump has broken that mold, by God's mercy, and he's on his process of getting rid of it. The one thing I see, and I think a lot of people here at National Liberty Alliance sees, is they lack the true knowledge of law. We need to wake these people up to what our true law system really is. And so that's what we're diligently working on. And again, we're diligently working on trying to get committees of safety going. If you look to the right side of our website and you come down towards the bottom here, you'll see information on committees of safety. For instance, we have visited and constituted every county in America. We have members in every state of this union, not necessarily in every county, but every state. We've got quite a few members. We've got almost 12,000. We have total county committees of safety being organized. We have 208 of them across America. We need 3,130 of them. But you know, again, it's slow moving because we're not professional. We're not being paid, and we need a lot of people putting a lot of time to really start working on things to be able to get a lot accomplished. And so for us, it's slow moving.
Well, it's true blue, and ultimately it's most worthwhile. It feels like there needs to be a preschool or some sort of remedial program, remedy, wherein
we have it right here.
On the phone with you tonight, or are not even aware of this movement, but are deep in their hearts, they know something's rotten in the state of Denmark, and they're not. It's not helped by another podcast in another interview format where there's not people meeting together. And I get it. Committee of Safety. That's the ideal vehicle in government, in process, in election, in the link between government by consent and government responsible to the people. Okay, so here's kind of I should have started this with a question, because you've got a queue of people who want to get on the phone with you, and
well, there's only one other person right now, so it's okay. Anybody else wants to get into the queue, it's a *6 and 1 if you're on a phone, and there should be a button there if you're on an app or browser. Yeah, go right ahead, Jan.
So there are almost personalities emerging of people that I've come to know who tend to call in, and you know, there's a pattern of them revisiting issues with you. And then there's the cold calls where you're getting direct questions about a particular case. And you've blessed me with guidance for a case a burglary where we were granted restitution. And I'm so motivated on so many fronts to complete this course and to complete the other courses. You are a just profound wealth of teaching and class material and coursework. But here's what I'm asking. I want to know more people at Liberty Alliance, okay? So that I'd like to be able to reach out to John, who is just on the phone, and say, hey, I hear you on the mock jury front. I'm not sure how we can work together, but we could get on the phone and compare some notes, and maybe there'd be some epiphanies and some synergistic kind of resolves. Same with Elizabeth, and I know you said send an email to make sure it was okay to get phone numbers, and I haven't done that yet, so I will, and I'll ask, may I contact people directly? But also, when you go on a podcast, the most recent I saw you with, you were with two other gentlemen with SG on, and it's exciting to listen to, right? But there's no interactive portion, say for, I guess, in the comments. I'm not a big comment gal, and maybe that's another mode of becoming involved. But I want to be able to meet up, at least regionally, with other people who are studying National Liberty Alliance material, and bond, and get some synergy.
All right. Well, in Wisconsin, we have 72 counties. You're not able to see my desktop. You're coming in on a phone, so I guess you can't see my desktop. But I'm sharing my desktop. You can go under our directory, click on directory, and you come down.
I've talked to Gary, for example.
Yeah, you click
I don't
on
know
your
if you know
state.
Gary, but
he's
the coordinator for the certain district or.
Anyway. We do have 212 members in that state. We only have one person, actually two people, that are starting committees of safety in that state. One in Columbia County and another one in Shawano. So those are the two counties. I mean, you can get their phone numbers here, and it might be good to give them a call and talk with them. I don't know, how far are you from Columbia County or Shawano County? Or I think
it's 2.5, 3 hours, I think.
Okay, that's
I've
pretty
got
far.
the geography right.
Yeah, sometimes what you could do if it's not too far is you can, maybe go and get involved with a committee of safety in the county next door, and eventually get other people from your county to get involved, and then eventually start a committee of safety within your county. But we do have the phone numbers of the individuals of people who are trying to get committees of safety going. Look, at the purpose of National Liberty Alliance is to educate people, bring people to a place where they can organize and communicate. But the key thing here is education. We give a huge education here, and most of our education is free. If you go under our education tab, for instance, you can see that we give a lot of different courses, and most of our courses are free. For instance, we have a foundation study that's free. We have a constitutional course 101 introduction that's free. We have a civics course that's free. We have a militia course that's free. Now, we have two courses that we require people to be, premium members, again, giving us $5 a month or more. And that's, they can then take the government by consent course, and they can take the jury administrator accredited course. Now, those are basic courses we have. You go through them. You actually, you answer questions at the end of each section, and you work your way through. And then, we have to answer all the questions to get all the way through. If you get something wrong, then you get to do those ones that you got wrong. The point is really, just getting people familiar and reading and learning. Now, we also have a lot of information on American history. We have lectures. We have different things, papers, Federalist papers, the Anti-Federalist papers, different papers on our Founding Fathers and what they thought about the political parties. We have biographies. We have the Continental Congress 2009. That's a huge thing there. We have articles and essays. We have educational videos. We have a lot of things on the law. We got court forms and process and procedures. All that stuff is free. But we do also give a court access and a common law course. And people can click on that. It's under our education tab here. And just come down and click on court access and the common law. And on that page, it gives an introduction, a lot of information on this particular course. Now, this is a course teaching people how to go into the court system, how to put the papers together, how to write the papers. And so it gives a lot of people, a lot of information for people for court access. And it's coming from the court, coming from the common law process. We do cover, their rules and give some strategies and thoughts, different mindsets. And you can take the first 3 hours for free on this page. There's a video right on this page. You can click on it and take that for free. And that'll give you the flavor, and it also gives you an insight and an introduction to everything that you're going to learn on that course. Now, that course costs $125. It's a 90-hour law course. If you went to college to get this particular court-on-court access as far as how due process works, I believe that course is a 45-hour course. And I think I just did a paper. Well, let me look. I think we have this on our front page. I think it's $2,600 a credit. Let's see. Yeah. Let me just read this. Click here to sign up for a comprehensive 90-hour law course on civic procedure from the common law perspective for $125. A college course on civil procedure is 5 credits. That's a 50 to 60-hour class. We give a 90-hour class. We do cover some of this civil law junk, for knowledge, so you understand certain things. The forms and everything are pretty much the same. We do give you information on the rules, but of course we're teaching rules of common law. But if they have a rule and you're in a court and it is in alignment with common law, then why not accept it? But then you have to put your foot down and make your argument if it's something repugnant. So 5 credits at $2,600 per credit, I think that comes to about $13,000 or $14,000 for that course. I think our course is better. And again, we're only 125. Now, there's a lot more involved in law. You know, there's contract law that they teach you, and different courses also that are required in order to become a lawyer. But the key course is getting into the court access. Okay, and it's they call it the civil procedure. We'll call it the civil procedure, but really it's the court access in the common law procedure is what it is. So again, you know, more education. We also have a higher education. Even with all that we've mentioned, we've got a lot more than that. You know, we have a lot of the great works up here that people can get involved in and read in. You know, again, I'd mentioned American history, but I'm trying to see where the other higher education is. It should be right here in this section. Articles and educational videos, law, no, topical, okay, public schools, books. Also, we have books. I'm not sure where I don't know why I can't find that tab. There is a tab here somewhere that lays out a lot of books. You can download and a lot of books in PDF form and go through. Blackstone, for instance. But also, you know, we've got 14 books. You'll find that under Welcome tab. You come down to books by John Darash. And I wrote a book, Government by Consent. It's a pretty large book. We got it. It's a hardcover, 8.5 by 11, and we only charge $39 for $40, $39.95. We have Court Access in the Common Law book, another one, $39. We have Memorandums of Law. We have Understanding the Federal Courts, and then we have a study of parables in the Book of Revelation. We have a book, What Must I Do to Be Saved? When is the Rapture? We have pocket handbooks, Committeeman handbooks, Committee of Safety Common Law handbook. We have Founding Document handbook. We have the County Sheriff Common Law handbook. We have the Petit Jury handbook. We have the Common Law handbook for the Grand Jury. And we have a Common Law Court handbook. Anybody going to court, this is a powerful book to have. And it's a handbook, you know, it's not expensive at all. And then we have another one that's called the Common Law Handbook. So we've got lots of books, we've got lots of courses, we have lots of PDF books, Spinoza, we got, you know, just a lot of the great works. So there's a heavy education. It depends on how much you want to get involved. But the basics is the Constitution and civics. And then, you know, really, I think a very important course for everybody should be really this court access in the common law, because you need to understand how the courts work. You need to understand how to write papers and what papers are necessary, how to do forms, how due process works, how to move the court, you know, all of those things. So now it's up to the people on the county level to get the committees of safety going. And you'll find some people who will want to tap into everything, okay, you know. But most people will get involved in this, maybe the education side of things, and others on the political side of things, or on the judicial side of things, you know, the militia. Everybody picks their idea of what they want to do. And then there'll be other committees that you'll have that you'll rise up because there's a need for them. And there may be a committee that's only temporary, you know, until you accomplish a particular goal. And once that goal is accomplished, then, you know, you can then, you know, dismantle that committee, that subcommittee. But to start a committee of safety, like I said, the key thing is to really work down this page under this tab, particularly handbooks, videos, and tools. And you'll find videos. We have National Liberty Alliance presents Government by Consent. That's a short video here. Committee of Safety, how to put the charter together, Committee of Safety charter. We also have Committee of Safety resolutions. We have a video on that. We have a plan on how to deal with the sheriff, how to connect with the sheriff, how to bring the sheriff into play and get him to be obedient to the common law or recall him. We also have a video on the educational committee, one on the political committee. And then all these handbooks, flyers, and different tools and videos and PowerPoints. I mean, we got so much. It'll take you a lifetime to go through all this stuff. But the point is that's what we're doing. We're trying to educate the people. And again, I'll go back to Jefferson. If the people expect to be ignorant and free, to not know these things, and to have liberty, they expect what never was and never will be. The Constitution cannot take care of itself. It cannot, empower itself. The people have to empower it. The people have to protect it. And if the people don't know it, how can they protect it? Right now, this nation runs totally outside of our Constitution. It's a mess. We have a problem. People need to get involved. Anything else, Jan?
Thanks, John. Just Godspeed. Appreciate everything that you're doing, and all the guys there, all gals. Thank you.
Appreciate it. Okay, we only got one other person in the queue, so if anybody else wants to get in, we got about 15 minutes. Star 6 and a 1 if you're on a phone, a button on an Apple browser. Veronica from Pennsylvania, how you doing? You got the mic. Go right ahead.
Oh, I didn't realize I thought I had hung up. What it is, John, is that I sent a link to Jan with the original 13th Amendment, and it was actually in textbooks back then, and just happened to be in the family library when I was cleaning house. So I just want you to know that you do have it now, okay? Thank you. I'm sorry about that. I didn't mean to speak. All right, thanks.
Yeah.
Oh, there's a call.
John, are you talking right now? Because we can't hear you.
Oh, yeah, I was. I'm sorry. I was muted, I guess. Anyway, I'm just reading this Federal Rules of Civil Procedure where they merged equity and common law. Okay? And this is found up on their website. This is on the Federal Judiciary's website that I downloaded this off of. And this is what it says. In September 16, 1938, in 1938, pursuant to an authority under the Rules Enabling Act. Now, how can Congress have new powers, new authority, and then empower another branch of government? They're not sovereign. They got powers and they got authorities, but they're not sovereign. They may be sovereign in their own person outside of the government, but in the government they work for us, and they're to be responding and doing things under the authorities and the powers that we gave them. They can't create new powers, not at all. And as a matter of fact, we go to, what is it, the 10th Amendment, which says, let me read that one, okay, not that they have the power to do this anyway, but the power is not delegated to the United States by the Constitution, and here's the key, nor forbidden by it, this new power is forbidden by it, to the states. Let's see, nor forbidden by it to the states or reserved to the states respectively or to the people. So any newfound powers, they can't empower themselves with a newfound power. They can't find power to power another branch of government, and that's what they did with the Rules Enabling Act. They had no power, no authority to do this. This was a violation of the Constitution. But anyway, let me finish reading it. Among the changes wrought by the rules was the elimination of the federal court's separate jurisdiction over suits in equity let's see, suits of equity. Well, I'll read this. A century-old system, they say, of English jurisprudence in which judges base decisions on general principles of fairness in situations where rigid applications of the common law rules would have brought about injustice. Now, just think about what they're saying. Common law rules, which is the law of God, which is simply, the rules he put into our heart. Thou shalt not kill, thou shalt not steal. We all know those things. That's innate. That God put it into our hearts. And we ought to look at all things with common sense. That's what common law is. And they say that God's law brought about injustice. And them being men, they claim that their law is just. And just think about what they're saying. I mean, that's pretty sad and pretty sick. And they've gotten away with it. And the only reason they got away with it because we the people have been ignorant and haven't been paying attention. That's the problem. It's time to kind of educate ourselves and take control. So they based the decision on general principles of fairness in situation where rigid application of the common law rules would have brought about injustice. That's wow, I can't believe they're even saying that. Under the new rules, suits in equity and suits of common law, which is natural law, were grouped together under the term civil action. They changed our law to civil law. That's Babylonian law. That's what civil law is. That's where it comes from. Control of the people. Fleece them and control them. Okay, I see Walt. I'll give you a minute or two. We just hit 11 o'clock, but go right ahead. You got the mic.
Yeah, good evening, John. I hope it's not too cold up there.
It's freezing.
Going along with that is if you look up this case, Erie Railroad versus Tompkins.
Yep.
In the 1938, it's acknowledging the United States of America went bankrupt. That's the bankers took over, had that rules enabling government. So it's a false bankruptcy. They use Article 6 to do a suicide treaty with the bankers, let them take over the United States of America. Because Roosevelt supposedly didn't pay off all the loan he borrowed with gold coin. So that's what happened. That's part of it, I think.
Yeah. Well, yeah, they put a lot of things and destroyed our entire nation, our laws, our way of life, who we are as a people. I mean, look, they got a mayor down there in New York City who put his hand on the Quran to enter office. I mean, why would someone swear on Baal, if that's the way to pronounce it? They don't worship the Creator, and that's a book of hate, not of love. And yet, a lot of people don't realize what happened with that. I mean, it's really that far out there. But people put their hands on the Bible all the time and then go and do their evil anyway, and that's a problem also. But again,
what year was the Enabling Act passed?
The Rules Enabling Act was passed in 1934.
Okay,
it went
that's
into
right.
effect,
On the same time the bankruptcy treaty. All this
went
happened
into effect in 1938, which I think is the same year you're talking, right?
Yeah.
Yeah, so that's when it went into effect in 1938. I think November or something like that of 1938. So yeah, you can see all this work. Look they had a lot of this stuff already pre-written up. The work that they built all of this upon, everything that they've been construction, because law is constructive, okay? And so the first piece of information, their foundation, was the Organic Act of 1871, and that incorporated the United States. That changed our whole system and process. And upon that, everything else is built. And everything else that they built was already planned out, I'm sure, and written up and ready to go. It just took time, so many years before they bring this out, and so many years before they bring that out, and so on, twisting arms and getting this through and that through, and coming up with the destructive 16th Amendment and the 17th Amendment, removing the 13th Amendment, and, and again, this couldn't happen if we were paying attention. If the people were educated, this never would have happened. But it did. And now to fix it, we've got to educate this administration to really spearhead what needs to be done. All right, with that, we've come to the end of our program. It's a couple of minutes after 11, so... Okay, good night, everybody. And our Bible study we have on Wednesday night. If anybody wants to come to it, it's at 7:30 p.m. Wednesday, right here in this room. And I think we're on part 3 of... goodness, let me take a quick look. I forget which study we're working on right now. Not sure whether I'd find that real quick. All right, anyway, anybody interested, we'll be here this Wednesday right here in this room, 7:30. Good night, everyone, and Lord willing, we'll see you next Monday. Good night.